It's a delight to be here, and I'm very excited to be the chair of this panel here and introduce our first speaker here. We have Dr. Susan Shay, who is an independent researcher and a member of the Heritage Research Group at the University of Cambridge. Susan has a PhD in Heritage from the University of Cambridge, a master's degree in Historic Preservation from Columbia University, and a bachelor's degree in architecture from Penn State. So much of her work is really to learn how to effectively use historic preservation as an economic vehicle to enhance community development. Please welcome Dr. Susan Shay.
To advance it? Advance it. You click on the arrows, right or left. Okay, great. Thank you. Thank you to the organizers of this conference for inviting me to participate. I also want to give thanks to the Native Hawaiian elders, the cultural experts, the academics, and members of the Native Hawaiian community who guided and informed my research. Their insight was invaluable in understanding the values and language and claims inherent in the following lawsuits. My intent in doing this research was to reveal and confirm a process of Indigenous empowerment that was assumed but had never been proven. I'm an architect, and this research came about as a result of work I've done in helping communities preserve and enhance their cultural and historic resources. I recognize that there are lawyers in the room, and I welcome your comments and corrections at the end of this talk. My research investigates the impact of heritage, which is the use of the past in the present, as David Lowenthal says, when it's used in the building of courtroom for narrative construction, and also the presentation of courtroom narratives by Indigenous people for the return or control of ancestral land. My research, therefore, involves legal terms and procedures that are very complex and perhaps not familiar to many in this room, since it's a genocide conference. Legal and combined with heritage can be very dense. And as a topic, I don't want to lose anybody in the process of talking about land claim cases. As a result, I'm going to show some really lovely pictures of Hawaii, where my case studies come from. And I'm going to put my main points that I want as the takeaways up front. So if you get lost and your eyes haze over when I get into the depth of the lawsuits, you'll remember the key takeaways when you leave the room. This information also serves as the basis for understanding the complexity of the lawsuits and how Indigenous empowerment came about in Hawaii through the process of involvement in law. These three cases took place over 25 years, and they're much more complex than I have time to cover in 20 minutes. And the evidence of empowerment is actually much more powerful than I have time to go over. Let's start with some basic explanations. Hawaii is very beautiful. There are 9 volcanic islands. There's limited habitable land, and a substantial portion of the usable land in Hawaii is land held in trust by the state of Hawaii, not the US government. And it's held in trust for Native Hawaiians. This is a holdover from when Hawaii was an independent constitutional monarchy. Heritage itself has use value. Heritage can support families through generational knowledge. It can encourage community cohesion with collective history and common experiences. It can unify nations with mutual goals, ambitions, values, and identity. But importantly, for the purposes of this talk, it can be a tool, and it can be a tool for economic, political, social, and environmental change and empowerment. The courtroom is one of the few places and this few public spheres that afford marginalized communities the opportunity, in theory, to challenge political hierarchies of power. There are commonalities between heritage and law. Both are focused on the past. Heritage is based on memory, and the law and legal reasoning are based on past rulings called precedents. Both use narrative or stories as basic building blocks. There are also differences. Heritage narratives, as I said, are based on communally shared memories. Legal narrative, or this is a legal definition, so I'm going to be very clear because of the lawyers here, are intentionally crafted and performed rhetorical truths. Keep that word in mind, truths, consciously created by lawyers to support an argument and achieve a specific objective. It's the truth as put together and presented in the court, not the story you tell, but the truth as put together by a lawyer. The court is a place of power and authority. Lawyers are trained to deliver narrative in ritualized rhetorical delivery, performing truth to power. In court, the lawyer is an actor, using verbal and nonverbal forms of communication to reach a desired conclusion. It is called a performance. There's a performer and there is an audience, and the performer needs to know the background of the audience in order to play to the audience and elicit certain responses. It's very similar to theater, and the conclusions, the lawyer always wants their conclusions, the emotions, to be favorable to their client. Distinct from literary or heritage storytelling, a narrative legal argument may result in a ruling with significant and sometimes violent social, political, or economic repercussions. As this slide shows, repetitive performance speech acts are transformative. If it's said, since the people in the court, the people who are bringing the case, are repeatedly attacked, they have to constantly defend themselves. And repetitive speech acts, I am, I will defend, I believe in this, are transformative and communicate a sense of power. Through this process of court performance, a new identity can come about. In other words, legal narratives do not just tell story, they compete in the court for dominance. Crucially, in the process of pursuing a claim and building, supporting, and presenting a narrative, when involved in court narrative construction, presentation, and defense, Indigenous claimants may discover previously undocumented and unrecognized values and practices. Such discoveries may reveal heritage previously lost, obscured, or discouraged due to historic discriminatory government policies. This information can enrich communities by revealing new forms of ancestral knowledge, things that were lost, things that have been forgotten, and tradition. Importantly, it can also be used, these things that are found, cultures, traditions, practices that were documented that have been consciously by the government put away in archives. It can be used to substantiate claims of traditional practice in the court. It's archival evidence. The court requires scientifically proven evidence, and archival evidence can be, and often is, considered scientifically proven evidence and recovered archival material, and it can substantiate claims. Now, I hope I haven't lost anybody. We're going to turn to Hawaii. Okay, your eyes haven't closed over yet. In Hawaii, unlike anywhere else in the US, there are two sets of laws on the books. One set was created in the 19th century when Hawaii was a modern indigenous constitutional monarchy. It was an independent nation. It had independent trade agreements with many nations throughout Europe and Asia, including the US. The laws were known as the Laws for Native Hawaiian Customary and Traditional Rights, and they were passed long ago to preserve the ancestral practices of the Native Hawaiian people. Throughout several political regimes after the monarchy was overthrown in 1893 until statehood in 1959, these laws were never abolished, nor were they interpreted in relationship to the contemporary society all throughout that whole period. However, the state and US government did appropriate significant symbols of Hawaiian culture and history, feeling that they were important to the identity of the state. So the first picture on the left is the last queen of Hawaii, the one who was overthrown, and her statue is in front of the State House for the state of Hawaii, where the legislature meets. The second one is the US government is using Pele. Pele is the only continuously honored god of the Hawaiian people, and she'll come up in the second court case. And Pele's hair It's volcanic strands from the eruptions. And that exhibit is at a national park. And the last is the state seal for the state of Hawaii. You can see around the bottom, it's in Hawaiian. That's the monarchs and the nation of Hawaii's the state motto from the nation of Hawaii. That's King Kamehameha on the left, who united the Hawaiian Islands after Cook was there. And that's the Hawaiian flag from the nation of Hawaii that's duplicated in two places. This is a symbol of Hawaiian protest. Hawaiian culture values peaceful resolutions to conflict. The following cases demonstrate the development of the laws that I'm talking about, the laws for customary and traditional rights. The cases are sequential, like one follows another, and each builds on and expands the rulings of the previous case. The first case is Kalipi versus Hawaiian Trust. William Kalipi was an impoverished subsistence farmer on the island of Molokai, attempting to assert his customary rights to access his ancestral property, a 1-acre parcel that had been given to his family in the 19th century, by filing a lawsuit against his wealthy and powerful neighbors with the assistance on the agricultural island of Molokai of a local legal aid lawyer. He had inherited this traditional property that had been passed down and needed to pass through his wealthy neighbors' lands, neighbors surrounding him who had huge parcels, to get to his tiny parcel. In his testimony, initially, Kalipi asserted his claim as a traditional Native Hawaiian landowner. However, as the court hearings proceeded and his identity and rights were questioned and attacked, Kalipi began to change over the course. And I'm just looking at the testimony in court, just what he said and how he said it. Kalipi began to say, I'm not a traditional Native Hawaiian. I'm indigenous and I'm Native Hawaiian. He declared that regulations cannot extinguish Native Hawaiian ancestral rights, and to state that indigenous rights are fundamental Aboriginal rights, not general rights of the state population, but rights that are specific and continuing for Native Hawaiian people. He encountered a lot of obstacles. We're talking the early 70s. The court and the public had little knowledge of Native Hawaiian history or rights. There were no legal handbooks on Native Hawaiian law. There was little Native scholarship on Hawaiian history, and there were no contemporary legal decisions on Native Hawaiian rights. No one had looked at these 19th century rights through all those different regimes. Evidence of the transformation of Kalipi himself and his personal empowerment are very clear in these lawsuits. By filing the case, he reinterpreted traditional values of peaceful cooperation. He came out from the community, and he didn't show humility and just be peaceful. He spoke out publicly. He defiantly and proudly defended his Native Hawaiian identity and rights after successive attacks. Remember, this is an impoverished subsistence farmer. He argued for reconsideration of the law on the basis of an alternative historical representation of Native Hawaiianness. We're not just peaceful people. We can take action too. And he transitioned during the course of the case, representing himself. First, he was an individual fighting for land rights, that's the beginning of the case, to claiming he was the lone representative of a community with deep ancestral foundations in Hawaii. In other words, I'm here alone, but I represent all the other Native Hawaiians in Hawaii. Importantly, he recontextualized history from a Native Hawaiian perspective. As a result of his efforts, there was greater willingness among Native Hawaiians to engage collectively for rights. Other people came forward, and the ancient law protecting Native Hawaiian practices was evaluated and determined relevant in the modern state of Hawaii. That 19th century laws protecting Native Hawaiian customs and traditions was confirmed in the state of Hawaii with this case. The second case, a number of years later, and these cases did overlap because they went on for many years, was Pele Defense versus Patty. In this case, Native Hawaiians created a legal nonprofit, a group of more informed, more active Native Hawaiians, formed a legal nonprofit under state and federal law. So it collect money. That's why you create a nonprofit, so you can actually start to raise money legally. And they forged alliance with many mainland Native groups, citizens associations, and national environmental organizations to create an effective legal strategy to fight a public-private initiative to extract geothermal energy from a protected natural resource area, a site that was also highly spiritually significant. The site is the home of Pele. You saw Pele's hair before. The goddess of the volcano, only continuously honored god by the Native Hawaiian people. There are Pele practitioners to this day, and their practices up until this point were kept secret, even from other Native Hawaiians. It's only the Pele practitioners on that island who knew the practices. The case was environmental, political, and cultural. Native Hawaiians felt the project would desecrate Pele because the volcano was active. That's where Pele lives, where the one island where the volcano is still active. It would destroy sacred lands. It would restrict religious worship and customary and traditional practice. And it would inappropriately use protected conservation land placed in trust for Native Hawaiians. Evidence of transformation, of identity empowerment. They demonstrated organized and professional leadership. They developed, I have 2 more cases to go. Okay, I'll try to talk faster. Developed alliances and a successful comprehensive strategy of activism. They created a national campaign that was in newspapers and on mainland, as they say in Hawaii, mainland newspapers and mainland television stations to raise awareness of their issues. This is early 90s, to build economic, social, and political capital for their cause. If you look in the LA Times, you can actually find this full page ad is there. They assumed power in the court, where the first case, because that little phrase can, at the end, Kalipi lost his case, but there was one little section added to the end of the ruling. The judge was Native Hawaiian, and he was the one who confirmed in the first case that Native Hawaiian 19th century protections were still in place, but he believed in mentoring. So he mentored his clerks. He brought in, went to the mainland universities, found Native Hawaiians that were in school and said, you have to come become a lawyer and work for me. Handpicked them, and they became active in this case. So the judge and one of the lawyers advising on the case had all been his mentees. Native Hawaiians this team created the first state cultural impact assessment to determine the impact of development on Native Hawaiian protected practices and site, which is still required today. It's like an EIS or an EA here. Provided expert testimony with scientifically proven evidence found in archives, and performed an assertive, self-confident identity that they needed for the future. This case built awareness nationally, but most importantly locally, that heritage was crucial to survival and could be used as a tool in the battle for recognition and rights. The activists gained organizational experience, increased Indigenous civic participation, and built confidence in their abilities. Their alliances with national organizations, environmental, political, social, built a huge amount of capital and helped fund future efforts. And the increase in Native Hawaiian in authorized positions of power in the courtroom and in universities shifted the cultural framework of legal interpretation toward an Indigenous perspective in Hawaii and demonstrated academic and professional leadership capability. I'm going to skip ahead to the last case and not talk about the cultural impact. Okay. The third case is the biggie. The other 2 were really significant, but this one is a landmark one. This is development, and Hawaii development is everything. It drives tourism and development, drive the economy of the state. The third case is called PASH, Public Access Shoreline Hawaii, and it was not started as a Native Hawaiian case. It was an environmental case, but PASH, the environmental organization, felt if they lost all of their claims, if they had a Native Hawaiian on board, they could claim those cultural protections, that this developer was impacting the cultural protections for Native Hawaiians. So they brought one guy in. And that's what kept the case going for many, many years, because the environmental claims failed. Residents of Hawaii, you can see the development. It starts out small. It was a Japanese developer. It kept getting bigger, this development and bigger. And there are Native Hawaiian archaeological sites on the property. They wanted to stop large-scale construction in the state of Hawaii by foreign developers. They wanted to protect the environment of Hawaii, which they feel is critical to their survival. They wanted there to be open space. They wanted to continue access. And they fought a very prolonged battle. And eventually the court allowed what are called amicus curiae, which is friends of the court briefs. And a huge number of Native Hawaiians and Native Hawaiian organizations organized to send in these friends of the court briefs to inform the court about Native Hawaiian rights and cultural protections and beliefs. And it was substantial. There were activists roll all over the state, and many Native Hawaiian groups drafted and submitted formal legal documentation. The state fought back. Opposition to this project threatened the growth of tourism, a major part of the state's economy. Native Hawaiians came to hearings, they testified individually, they came all the time, and there was an evident shift in the defensive rights from a defensive rights to a demand for political recognition and a reconsideration of all narratives of Native Hawaiians of the past. And the Native Hawaiians proposed that the state should integrate cultural values into the law of the state to resolve social and political differences. The impact was dramatic on the community, and there was a huge evolution in mindset from we are the victims to we are the survivors. And there was an amazing amount of invigorated pride. With each case, Native Hawaiians performed a stronger and more powerful form of Hawaiianness. And they were more self-confident, more assertive, more proficient, and certainly more professional in building and presenting legal and defending legal narratives. As the cases proceeded, they filled more authorized positions in the court and were greater political action agents for change. I'm almost done. Last paragraph. Through this effective demonstration of power, Native Hawaiians took the opportunity to create an economic and a political use value for heritage. That's a really important thing to walk away with, that heritage can have other values. Negotiating its application by environmental organizations to the mutual benefit of both groups. In this role, Native Hawaiians were performing power in the court and were therefore the embodiment of power. As some of the people involved in this case, this is the School of Hawaiian Knowledge at University of Hawaii. There's now a volume. One of the mentees of the first judge, created the Native Hawaiian Law Center at the University of Hawaii, and she wrote this edited Native Hawaiian law. So there's now a document that goes through all of those 19th century law and all the rulings, and she has a community legal program. She also was instrumental in founding the Native Hawaiian Legal Corporation that helps Native Hawaiians file their own cases. And this is King Kamehameha in front of the state Supreme Court. So there's the state of Hawaii respects and honors Native Hawaiian history, has integrated it into the state, into law, and honors the past rulers of the independent nation of Hawaii. And there's King Kamehameha. I'm presenting this case study as an example of an empowerment process that may be of significant interest to other groups struggling for land control and sovereignty. Thank you.
Yeah, really interesting presentation. Thank you. I was just curious, are most of the Native Hawaiians considered residents of the state, or are they considered a sovereign nation? And so how does that work? And is most of that in state courts?
They can't be considered a sovereign nation here. They can't be considered a sovereign nation according to US law, because you can't define a border around a territory. They're on islands. So the idea of a reservation means that you have a set of borders, and when you're on different islands. So they're Pacific Islanders, they're not Native Americans, and they've now, many laws cover them. They've been put into a lot of laws that cover Native American rights, but they're a different category, and they've been fighting for some sort of sovereignty, but they've never resolved it. Remember, the trust land is not held by the federal government. It was a condition of statehood because it's so incredibly messy. The lands that are held in trust are a carryover from the overthrow of the independent nation, which was many considered to be done illegally because it didn't follow standard US procedure when it happened. So it's in this quasi area where there's no legal precedent to decide how to determine what to do with it. And it's so messy that it was a condition of statehood when Hawaii joined the US. The state had to accept the responsibility for a huge amount of land that's held in trust for Native Hawaiians. But there's a blood quantum, and it's similar to Native Hawaiians, where the federal government intentionally is trying to figure out who's Native Hawaiian and who's not for the purposes of benefits, but it's unintentionally divisive because it divides families, it divides communities on who can get homestead land, who can get certain economic benefits or political benefits where others can't.
I don't really have a comment or question, but I'm sitting next to somebody who had a very major insight into his own research as a result of your talk. And I could try to restate what he said so well, but he's a grad student here at USC. He's Turtle Mountain Chippewa, and he had an aha moment while you were speaking, and I would love for you to connect.
Wonderful.
Well, thank you for that. I just wanted to say thank you very much. I think this research is very important. And as far as my own research, I study Indigenous sovereignty and tribal constitutions in particular. But when you were speaking, I just kind of felt like I found kind of a missing key, a missing ingredient in my own research, looking at this kind of legal precedent and incorporating the customary law. So, let's keep in touch.
Okay.
Thank you so much.
My pleasure.
Can check on the Zoom really quick and see if there's.
I think there's a question over here. In the front.
Thank you so much for your work. I know really little about Indigenous law, and especially as it pertains to Hawaii. And I was wondering how, the precedent that a lot of Indigenous lawyers have set there can impact or influence the situation with the Hawaiian telescope. Is it Mauna Kea?
Mauna Kea.
Yeah. So I'm wondering, how that might influence the things that have been established, right, in the past few years with the land development and I think you were mentioning the assessment.
Cultural impact assessment.
Yeah, cultural impact assessment, how that might influence the protection of ancestral lands and also respected places.
I have a great deal of respect for the Native Hawaiian efforts for sovereignty and land control, and for the people that I met. And I try very hard not to study or impact or analyze their political actions or their culture. The Mauna Kea has divided the community again. Hawaiians love technology, and they love new ideas, and they've survived in the most remote archipelago in the world because they were willing to adapt, and their culture has adapted. They arrived there from someplace in the Pacific long ago, and they continue to adapt. So scientific discovery, when Cook came, the Hawaiians were pulling the nails out of the ship because they'd never seen iron before, and this is cool. And they took to literacy rapidly, new technology. Wow, we can use this. So the telescopes, on the one hand, are science, and they like science. And then there are cultural practitioners who say, well, science is important, but we're cultural practitioners on the same spot where your science is. So it's divided the community. What's more important to many is that it's on trust land and having a voice and having a say. And there have been lots of negotiations. So there's a Keck telescope, a big Keck telescope. The telescope that was going to build was multinational. So there were many, it was an international fight as well as a local fight, because there was so much money coming into Hawaii to build this enormous telescope. I believe it was the 13th on the mountain, so it's not the first. Many have gone up there, but it's a question of control. If it's on indigenous land, where's our voice? And how much of a voice should we have? And what about that trust land? It's the airport, it's University of Hawaii, it's the biggest shopping center in Oahu. It's all trust land. We should have a say that trust land is for our benefit. So the complications of the building of that telescope were enormous, not just cultural. And there were lawyers involved. I also know Native Hawaiian PhDs on both sides of the argument. But the fact that their voice is there and that they're informed voices and that they're not afraid to come out publicly and speak. I have a chapter in a book about how the Native Hawaiians used technology to fight the Mauna Kea telescope, how they very cleverly, only 2.4 million people in Hawaii, and only 25% of them are Native Hawaiian. You might actually have a larger Native Hawaiian population in Las Vegas than you do living in the islands now. Hawaii is so expensive. But they figured out cleverly how to marshal the resources of the internet to build political clout to fight this multinational telescope. And it was enormously successful because the support within the scientific community, wait a minute, we have to think about this with their cultural claims here. What's our desire in science? Can we pursue science to such a degree that we destroy the safety of communities because they need to feel secure? And those discussions were right online, and it was all triggered by Native Hawaiians saying, wait a minute. So it's quite an amazing community, and the last 50 years, they've been amazingly proactive from Hawaii.
Again, thank you, Dr. Shay. That was an amazing presentation, and definitely do need more time. And I do have a hard job, I must say. So I didn't mean to cut you off, but I know there's a lot more to be shared.